Yes, sir, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Um, uh, Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime had took place prior to the unlawful traffic stop. Okay. The state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis exist to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. Um, for one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. Uh, an injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, well, I'll just repeat what I said. So this situation happened from an unlawful traffic stop um, without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021, approximately around the time when the case was first initiated. I did upload and file on record evidence of that notice of rejection as an.
Welcome back, courtroom enthusiasts. Today, we've got a classic case of a sovereign citizen thinking they can outsmart the system in a Texas court. Meet Antoine Jermaine Davis Bay, who's not only fighting his case, but also filing motion after motion, this time asking for the judge to reconsider a previous denial. Now, if you've seen these kinds of motions before, you know the drill. There's always a bit of drama, a lot of nonsense, and a judge who's just trying to keep the process moving. But don't blink, because the real fun begins when the judge starts shutting down this whole unlawful arrest argument. Let's dive in and see how this plays out. Stick around till the end, and tell me, how far is too far when it comes to defending yourself?
Also, I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest or search without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. Um, the officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to um, prosecute a traffic citation against me. And also the adjoining case that was with it.
So right out of the gate, Davis Bay is throwing down his argument. Hypothetical suspicion versus concrete crime. He's basically claiming that because no real crime took place before the traffic stop, the entire arrest should be thrown out. Now, this is where things get sticky. Yes, the officer has to have probable cause, but the mere fact that someone gets pulled over doesn't automatically mean their rights are violated. If every single traffic stop was challenged like this, we'd never get anything done in court. So, let's see how the judge handles this, because this argument's not exactly as slant.
The Fifth and 14th Amendment requires fair treatment through the normal judicial system, protects against, due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what.
Notice how the judge has to step in here. He's asking Davis Bay to speak slower and face the camera so the court reporter can actually understand him. It's a small moment, but it's a nice peek into how critical communication is in a courtroom. When you're making legal arguments, especially complex ones, you need to be clear and precise. It's not enough to just throw out legalese and expect the judge and the court to just roll with it. So, Davis Bay, take a breath, slow down, and try.
What I received of that, which is pretty much a blank report, and it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits.
Here's the thing. Davis Bay is making the argument that because the possession of marijuana charge was dismissed, all evidence from the stop should be thrown out. Now, I get it. This kind of thinking sounds logical at first. But here's the kicker. Dismissing a charge doesn't automatically invalidate the traffic stop. The stop could still be legitimate, and evidence collected from it can still stand. Davis Bay is playing the throw everything out card, but that's not how it works in practice. We're about to see if the judge agrees with him or if he's just wasting everyone's time.
Also, the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed case dismissed under the fruit of poisonous tree doctrine, and that's Wong Sun versus United States, followed by citation. This doctrine,
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
yes, ma'am. I mean, yes, sir. Wong Sun is Wong, first name, last name Sun, Sun. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade.
All right. Now Davis Bay is pivoting to a due process argument, invoking the 5th and 14th Amendments, claiming that his rights to a fair hearing were violated. And yes, due process is critical in any criminal case. But the problem here is he's trying to use due process as a blanket defense without explaining how it specifically applies to his case. If anything, it seems like a generic argument trying to distract from the core issue. The judge is no fool, though. He's heard this song and dance before. Let's see how he responds to these legal...
Thank you. Your time is up. Your 10 minutes. State, quick question before you respond. Has Mr. Bay had access to discovery in this case? He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was...
Will you
Okay.
spell that, sir?
last bayby@gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did
So
you
the
request it? Who did you request it from?
the Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately.
Now we hit a turning point in this case, and we've got a great example of why procedure matters. Davis Bay is demanding affidavits and proper reports, but here's the thing. The prosecutor isn't obligated to present everything during this hearing, and not having every document doesn't automatically prove the case is invalid. This is where Davis Bay might be overplaying his hand. He's acting like every minor detail needs to be perfect, but the real issue is whether the arrest was reasonable at the time. Sometimes, even if you don't have a full paper trail,
Following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding.
Now, Davis Bay is pulling out the big guns with the fruit of the poisonous tree doctrine, which argues that if the initial arrest was illegal, then everything that followed, including evidence gathered, should be inadmissible. This is an important legal principle, but here's the catch. For it to apply, there has to be a clear violation of the law from the very start. The fact that the case is still moving forward means the judge isn't convinced that the arrest was